Hello, all. Yesterday, as you would all know, the Supreme Court declared the judgment in Anuradha Bhasin versus Union of India. This case concerned the legality of the telecommunications and internet shutdown in Jammu and Kashmir for the last 5 odd months, ever since the Parliament made those changes to Article 370 of the Constitution that affected the special status of the former state. Here, I'm not venturing to discuss this entire judgment. Through this medium of the internet, I hope to clarify only one critical aspect of this decision. Now, coming to the judgment, the Supreme Court had framed a total of 5 issues, and I'll focus on the second question that the court had framed, which was whether the freedom of expression and freedom to practice any trade over the internet is a part of the Part 3 fundamental rights. Paragraphs ranging from 19 to 28 of the original copy of the Supreme Court judgment are relevant to understand the decision on this point. I have attached a highlighted version of this judgment in the description below for your benefit. Ever since the judgment was delivered yesterday in the morning, over most of the social media platforms like Twitter and Instagram, and even one or two news portals online, many persons, including law students, lawyers, journalists, and other activists, have stated that the SC has declared the right to access internet is a fundamental right. In fact, even the main petitioner, Anuradha Bhasin, has tweeted in a similar manner. I'm sure you can outwardly sense the generality of this statement, right? Keep that in mind. However, a quick reading of this judgment's relevant paragraphs as mentioned above will even more clearly reveal that the SC did not declare the right to access the internet as a fundamental right in those general terms as being expressed on social media currently. Let me try to take you through some of the most significant parts of the judgment to show the same. In paragraph 19, a very generic paragraph, the court stated that the petitioner's contention is that the impugned shutdown has restricted freedom of speech and expression and the right to free trade of the people in Jammu and Kashmir. This is in a way indicative of the direction of the court's judgment. More importantly, Justice Ramana, in paragraph 22 of the judgment, states that, I'm quoting him, now we need to concern ourselves about the freedom of expression over the medium of internet. He starts with these words to sort of unambiguously state that in today's world, the internet stands as the most utilized and accessible medium of exchange of information and news. Further, in paragraph 24, he goes on to state that the importance of internet cannot be underestimated, as from morning to night we are encapsulated within the cyberspace, and our most basic activities are enabled by the use of internet. And as an obvious conclusion, in paragraph 26, he states that expression through the internet has gained contemporary relevance, and therefore freedom of expression through internet is an integral part of Article 19(1)(a) of the Indian Constitution. And of course, any restriction on the same must be in consonance with Article 19 Clause 2's reasonable restrictions. Further, paragraph 27 also confirms that conducting commerce and trade through the internet is also a fundamental right under Article 19(1)(g). So this is the basic crux of this judgment. Now coming to the most important parts that I want to focus on. The judgment in paragraph 25 distinguishes between the internet as a tool and the freedom of expression through the internet as two different things. This is the nuance which has, intentionally or unintentionally escaped the discourse over the last few hours since the judgment. Apart from paragraph 25, paragraph 28 states that, I want to sort of read it out in verbatim. The court says, none of the counsels have argued for declaring the right to access the internet as a fundamental right, and therefore we are not expressing any view on the same. We are confining ourselves to declaring that the right to freedom of speech under Article 19(1)(a) and the right to carry on any trade or business under 19(1)(g) using the medium of internet is constitutionally protected. Right? Essentially, this is a basic judgment about the right to freedom of doing certain activities over a different medium than the mainstream ones, and not essentially about the use of that medium for all other purposes that may be associated with it. So it's not that generalized judgment about a particular medium, in this particular case, the internet. Hence, this decision is not at all a precedent for future cases to show that, the access to internet generally is a fundamental right. Not at all. Future cases will have to determine how this right to access internet will be enlarged beyond the specifics discussed by the court in this case. So, besides, these observations should underline the importance of reading judgments and legislations before actually commenting upon them. I don't think we can blame the journalists too much for that, to find all these nuances in a judgment. But as lawyers, we ought to take that responsibility forward. Okay. Thank you for listening, all of you.